Yes.
My Lord Moylan, I'll canter through this as quickly as I can. September 2020, the parents decide to give monies to James and the siblings, and that's in 63 Roman 1, page 130. Late 2020, early 2021, that the husband no substantial to him, that's paragraph 62, same age. One of the evidential planks supporting that conclusion is at 132 in Roman 5. The judge accounts the properties that the husband has looked at during that period, and I'm going to document in the supplemental. .9 million Australian, which is at Roman 4 at 131. The judge finds in the same paragraph in 4 that this was deliberate, intended to fund 4 payments to Edward, James, husband, Teresa, Isabel. The reason 80 million Australian dollars, but 60 million is that they collectively bought about 20 million, which was to be netted off, and that's the last sentence of that paragraph. The money was coming. And then previously looked at the strong cause trouble. judge found that the husband of the wife found have oversight, do you, of where he's put that money? I gave without thought of recognition. Do you remember when Ernest brought the money back to Singapore, it sat in a stakeholder account? She says, I had nothing to do with that. You know what a stakeholder account is, roughly. Nothing like that. There is no arrangement like that, is there? This is just James's money now. It is not my money, it is James's money. And you have no idea how James or your other children or your grandchildren spend their money unless they tell you. Correct. And you cannot, because they have to account for it themselves. You cannot police what happens to that money, can you? I cannot police what happens to that money. It was a gift. And if James wants to take Christina out for dinner, that is a matter for him, is it not? I think it would be fantastic. And if James wanted to take Christina on holiday, that would be fantastic. And if he wanted to give her £20,000, that would be fantastic. If that is what he wants to do, that is his choice. Thank you. And then Mr. Todd cross-examines, and at the top of page 341, Mr. Todd acting for the husband, of course, if James wanted to give Christina £10 million or $10 million for that matter, and use your gift for those purposes, what would your view be of that? My view is that James has the money. It is James's money. I do not have to ask what he does with it. Well, yes, what if James did not agree to 10 million, but instead, as a result of a court, he had to hand over that money? Would that affect your view? It would be very unfortunate. I'm back on message at this in this cross-examination. When you gave the gift to James, did you intend that Christina should get that money? No, but we've had the evidence before, rather than the evidence of a cross-examination by a friendly party.
Rather leading question.
Again, I think we've been here before. Ending the March period. The judge found in the wife only discovered about the fraud when the husband sought to enforce the order. And having resisted providing a disclosure, so this isn't the disclosure within these proceedings, it's the disclosure as part of the enforcement proceedings, an order was made that he make disclosure in Form E2, at which point, at the start of 2023, significant sums in his accounts were discovered. So he and my client's family then sought to suppress, and this is why we've gone through this long chronology, sought to suppress and deceive the court as to the true story about the decision to pay the $14 million, and presented the decision to pay him as being linked to his cancer diagnosis, when in fact that he knew that he was going to receive a substantial gift from as long ago as 2020, and he knew the from July 2021. So the first of the judge's findings. Page 5 of the authorities fund. Paragraph 96. This is referring to Mr. Justice Mostyn's earlier judgment in Cathcart and Owens. It says where he said that deliberate non-disclosure is a species or subset of fraud. He explained that fraud and non-disclosure are separately identified as grounds of set-aside under family procedure rule, because there are some rare cases where material non-disclosure is inadvertent and therefore not fraudulent. So non-disclosure can be either fraudulent or inadvertent. And the judge plainly decides, he may not use the word, but he plainly decides that this is fraudulent non-disclosure. That is really the only conclusion that can be drawn from his central findings about this, which are 61. So if we go to core bundle 61. Mr. Todd has conceded that until the duty of disclosure came to an end, whether this was on the 4th or the 18th of March, and in the end nothing turns on the difference between the two March dates, the husband had a duty to disclose to the wife and to the court any knowledge acquired by him that he was likely to receive a substantial gift of money from the wife's parents' mother, which would be likely to have an effect on the financial negotiations between the wife and the husband. And at 62, I have, in the end, reached the clear conclusion that the husband acquired this knowledge a long time before March 2022. I'm satisfied on the balance of probabilities that he had this knowledge, including as to the likely size of the first tranche of the gift, i.e. 20 million Australian dollars or 14.7 million US dollars, at least by July 2021. So we are very much in fraudulent non-disclosure territory. Back to Entwistle, where the relevant paragraphs of Charland, which you looked at this morning with Mr. Todd, paragraph 32 and 33, are set out under or as part of paragraph 97. If non-disclosure is found to be intentionally fraudulent, then it's assumed to be material, and the burden of showing otherwise lies with the representor, in this case the husband, and those principles, that principle can be deduced from 97. I'm not going to read it out.
There was a discussion this morning
Yes.
about...
My Lord Justice Nugee's two-stage test.
Yes. And the material, or to what material the word material applies. Where were you just reading from? I've lost it now.
I wasn't reading, I don't think.
Were you not?
No. It was my paraphrasing.
Right.
But I'm...
So it's you cannot be allowed to deny its materiality is 32, and then 33, picking up Lord Brandon probably from Jenkins Lewis.
Yes.
Is the only exception is where the court is satisfied that it wouldn't make any difference.
Yes, whether Charland expands Livesey and Jenkins is arguable. The wording goes a bit further, doesn't it? Because the fraud would not have influenced a reasonable person to agree to it, nor had it known then what it knows now, would the court have made a significantly different order. Not my submission that you have to decide a distinction between Livesey and Charland. Charland is effectively about the burden.
And I think, sorry, you finished with Entwistle?
Yes, I have.
Because there were also some observations about this in Go. Now, the majority decision in that case, or the decision in that case, the judgment was by Lord Wilson, and everybody else agreed with him. And I don't think Lord Wilson in his judgment revisits what I call the Charland point. He deals with the effect of the recital, and that you can't exonerate yourself from making full disclosure simply by a recital saying that the other party believes you haven't made disclosure. But Lord Neuberger does say something about it in paragraphs 44 and 45. Now, and there, in the last part of paragraph 44, I think it's 44, not 45, but the last part, he says, where a party's disclosure was inadvertent, there is no presumption that it was material, and the onus is on the other party to show the proper disclosure would, on the balance of probabilities, have led to a different order, whereas where a party's non-disclosure was intentional, it is deemed to be material, so that it is presumed the proper disclosure would have led to a different order. So that is using material in the sense of would have led to a different order, significantly different, whatever, substantially different, or different. So that would suggest that it's not really, that if you make, and as my Lord said this morning, if the fact which you are alleged not to disclose was an immaterial fact, then you haven't breached your obligation to give full and frank disclosure. So it's not non-disclosure. But I think often the word material in this context is used in has it had a material, would it have a material effect?
Yes.
Do you disagree with that or not?
In effect, there's often an approach which elides the two-stage process that was being suggested by my Lord Justice Nugee.
Yes.
Into one question. And in fact, we can see that in Mr. Todd's own grounds, where materiality represents both parts of the question.
I.e., has there been material non-disclosure in the sense of non-disclosure of a relevant fact
that would have
in respect of which your obligation applies?
It's
Yes.
It's difficult to see what other metric when you think about it, the metric of question 2 is the same as the metric of question 1, which is probably why people are a bit often ill-disciplined about dividing it into 2 questions, because even Lord Newburger has elided question 1 and 2 in the first part.
Well, I'm not sure he has, because I think he's saying it's first of all you have to identify, has there been non-disclosure? Then you have to decide whether that non-disclosure was material in the sense of, and I'm not talking about on whom the obligation lies to establish it, material in the sense of, and that's where I say whether it's significant, substantially different, would, could, whatever it might have, whatever the approach might be. But materiality is used in that context.
But he appears here to be leaving out the category of it's so obvious you don't have to mention the £10 in the bank account.
Well, that's because he's assuming non-disclosure.
But that non-disclosure might be of the £10 in the bank account.
No, because then it wouldn't be non-disclosure. It wouldn't be, well...
Well, it would be, wouldn't it? I mean,
well, no, because your disclosure obligations only apply in respect of material facts. So if you don't disclose an immaterial fact, you aren't guilty of non-disclosure.
Well, without wanting to be difficult about this, why did Lord Brandon give us the £10 example? Or was is that not from?
I don't think it is.
No, it isn't from that, is it? No, that's from Mr. Todd. Sorry. So,
okay.
So I've elevated it into Lord Brandon's decision. Apologies for
Too
that.
kind.
Anyway, thank you. Okay. Right. Yes. So where to next?
Dealing with the judge's approach. Which is in the core bundle at 133. At 64. So having reached this conclusion, it prima facie follows that I should set aside the March 22 consent order on the grounds of material non-disclosure, on the basis that the husband should have informed the wife of this development, i.e. what he knew about the intervener's intentions in July 2021. So we say that this assumption of materiality in circumstances where he's set out a great deal of the facts of the case is well, obvious, first of all, but second, that it's at the right stage of the test, but it wouldn't really matter if it were. It doesn't really matter how you approach the two-stage question, so long as you ask both questions, and he does that within paragraph 64 and paragraph 65. He then goes on to, I see, this is where I've got the £10 from. It's from this paragraph. He then goes on to deal with, Mr. Todd says that even if I reach this conclusion, I should not have set aside the order because the non-disclosure is not material, that its timely disclosure would have, or at least should have, made no difference to the outcome of the financial remedies negotiations. In his closing submission, he suggested that its non-disclosure was no more significant than the non-disclosure of a bank account with £10 in it, and argued that the case falls within the Livesley and Jenkins exemption.
Which that the submission he's recounting there, the no difference to the outcome,
Yes,
is
it's the second question.
Well, if there is a second question.
Yes.
Yes. Exactly.
I think the judge is treating it all as one question. It's because the non-disclosure is not material, that it's timely disclosure.
Well, he goes, but my lord, at 65, he doesn't pose it as a second question, but effectively he deals with what perhaps my lord would describe as the second question. I've considered Mr. Todd's suggestions, but I don't accept them. I shall make some comments below on where non-disclosure may take the case in terms of substantive merits and ongoing procedural decisions. But wherever the burden of proof lies, I cannot agree that the knowledge that the wife's parents' mother were planning to gift a substantial amount of money to the husband would have made no difference to the negotiations or outcome of the case. I can readily see that the uncertainties left in the order in relation to the wife's loan to her parents and ongoing John Manners' income might well have been treated quite differently if there was more available capital. In my view, the information would have made a significant difference and is a long way from being de minimis. Now, one of the important things to note here is what was and what wasn't before the judge. He wasn't deciding the new financial remedies claim. This is more akin, this set-aside application is more akin to a summary judgment. He's dealing with a point. If he doesn't dismiss on a summary basis, then he goes on to decide. There are two ways of going on. You can either go on in a foreshortened manner, dealing simply with the issues that haven't been disclosed. If there were sort of one freestanding bank account with £100,000 in, which was matrimonial, which should have been divided 50-50, a judge might say, well, we're just going to have a half-day hearing to determine how that should be divided. Or you have a full-blown financial remedies. And that question has not yet been decided which route we're going to be going down. And
he's given directions for it, but it's all been stayed pending this appeal.
Yes. And the question of, for instance, how far he could decide what orders would be made is much hamstrung by the fact that he didn't have, for instance, the Forms E from 2017 and 2018, which informed the parties' needs cases and also their capital cases at that point, but the points that I already made at the beginning of my submissions before lunch. What both parties were saying at the beginning of the proceedings about their needs, how they were quantifying their income and their capital needs. And so there is no, 65 is not a definitive answer to the question of, the judge doesn't have to ask himself, what are the substantive orders that I now make? And I have to answer that question as part of the Moylan test. All he has to do, there is a second question, is to answer what sort of differences there might be. And he immediately highlights on two, which is the income that the wife has. So she has a fixed but uncertain income recorded in the order. That could have been dealt with by way of capitalised maintenance from the husband, had it been known that that money was coming in. The question as to the loans, again, no doubt a judge might well, and this is obviously what the judge was thinking about, he probably would have said, well, I would say that the liability for those loans should lie with the husband, not with the wife. And then my lord has already made the point in respect to the payment of $850,000. That point might be looked at again. But the whole assessment of needs is to be done not by what the parties' needs were in 2022 and what their resources were in 2022. Once you've set aside the order, you're then looking at what their needs now are and what their needs.
Also, not what the parties might have been prepared to compromise, given the assets available, and what the court might do if there's no compromise.
Yes, and the metric, one of the metrics of need, are the assets in the case. The point that my Lord Justice Moylan made when he said, well, there are many cases where parties' needs are not met. It goes without saying. So if you suddenly have another, the non-disclosure relates to £12 million, but there's also the additional monies that arrive after that. All of those then go into the melting pot now of what the need is. But the question, putting the judge's mind back to 2022, is what would everyone have thought in 2022, March 2022, if there had been another £12 million in a £6 million case? We should start all over again. It's not a comparable case. A case with £18 million worth of assets as opposed to £6 million is completely different. And that the way in which everyone would approach it, which is one of the reasons why the judge is able to deal with this part of the case so swiftly. He's gone into great detail about his findings. He's made his findings that lead him to set aside, and the elephant in the paragraphs, as it were, is that £12 million has arrived, and then another $20 million. And of course, in those circumstances, it's whether there are two questions or one question or two questions, it's material and it's going to affect the outcome of the case, because any reasonable person is going to take a different view of negotiations and any court is likely to make a different order.
He doesn't need to be satisfied that the court would make a different order, only that there's a real prospect of it, doesn't
Yes.
it? Because the onus is on, in a deliberate non-disclosure case, the onus is on the person seeking to hold on to the order to show that it would not have made a difference. That's what Baroness Harris says.
Yes.
So if you're left in a state of uncertainty, but you can see it might or might not have made a difference, then you haven't discharged that onus. Is that the position?
Well, yes, but we're not close to that. That might be the case if we were talking about £100,000.
Yeah.
But we're talking about a life-changing amount of money that's come into this case. And that's why the judge's reaction might on its face look a little bit superficial. It's because it's blindingly obvious. Yeah, and as my junior reminds me, 6 million is the best case scenario, so I'm taking the highest possible figure. It was a range of 3.5 to 6. I'm going now to turn to the grounds, which are in the core bundle at page 90.
Just before you do that, one of the words used in the authorities, including by Baroness Harris, is substantial, which I think goes back to Jenkins, Livesey and Jenkins. Make a substantial difference.
Yeah,
What's the import of that? How big does substantial have to be?
depends on the case, doesn't it?
Yes, but in a case like this, I mean,
It's-
obviously £10 is insubstantial.
Yes.
But at what stage? I mean, does it have to make a big difference? Or is it just anything that's more than de minimis, which is what the judge seems to have said?
Well, on the face of the authorities, it appears to be anything that's more than de minimis, but we don't have to go there in this case because we can't be in that territory.
No.
It's ignoring the reality, the reality of the arrival of £12 million.
Yes.
And what to strive for principles when you have a figure which no one could describe as anything other than substantial is a dangerous route
Yes,
to go
I see.
down.
Yes, thank you.
I mean, I accept, my lord, that one might want to, in a different case or in produce, as it were, a little table of the multiple that a substantial means by reference to the original assets, but that in itself would be dangerous, my lord.
Sometimes substantial means quite a lot, big. But sometimes it just means
Important.
anything that's not insubstantial. And they're quite different concepts.
They are, but this is both.
This is
This is
yes. So you don't need to decide.
Well, it's only enough that it's the latter, surely, because I read it as being substantial and significant and being used more or less interchangeably in the authorities as meaning the same thing. I mean, I don't think it's a question of quantification
no,
necessarily.
but inevitably
The one might lead to the other, but I think it's all about significance.
it is. But in a case that's focused on dividing up money, inevitably the quantum of the money is going
Yeah.
to be
Yeah.
the metric of determination. Yes. And my lady's right, it's significant in Charlotte. If we go in the core bundle to page 90, we find the ground of appeal, which is subdivided into two parts, and then the second part is subdivided into two further parts. So the first ground is the first A that's contained in the first paragraph. The judge either misdirected himself as to the extent to which he should have regard to materiality. So the first ground is that he misdirected himself as to the extent to which he should have regard to materiality. Does my lady?
Well, I just don't understand that as a concept. either it's material or it's not. You've got to take it into account. So why is it a question of extent? That's just mangled English.
The judge plainly took into account materiality in the paragraphs we've looked at.
Yes.
So we say that there's nothing in the first part of the one ground, A. The second part, he failed to give sufficient weight as to whether the non-disclosure was material. This was an evaluative exercise, not a discretionary one, in particular. So this part, which is he failed to give sufficient weight to whether the non-disclosure was material, is then subdivided into two parts. A, the court went into error in finding that there was relevant non-disclosure. The wife knew that there would be very substantial support from her parents to their son-in-law. She must have known that it would have been of a similar scale as the actual gifts. The judge held that the gift to the husband was foreseeable and foreseen, albeit the fact of the impending gift had not been disclosed. Well, the source of this complaint would appear to be paragraph 68, which is at 134 of the judgment. Sorry, of the bundle. Had the husband, this is the final paragraph of the two paragraphs dealing with the barbarous. Had the husband genuinely not known anything about the likely arrival of gifts until July 2022, then the case might have looked very different, and an application on the principles of barter and the husband is doing in his grounds of appeal is using concepts from, importing concepts from the barter jurisdiction into the non-disclosure set-aside jurisdiction. I'm trying to confuse by saying because the wife was suspicious that something might eventuate, that when it eventuates, that exonerates him from his duty of full and frank disclosure. So we say this is just torturing the law in order to make a point that doesn't get off the ground. The last part of the ground of appeal is having found that there was deliberate non-disclosure, the court did not sufficiently address as to how that made a material difference to the award. It was a matter of law that the court needed to find that there was both relevant non-disclosure and that it was material. Pause to say that's exactly what the court did. The gift received by the husband from his parents postdated the separation by 5 years. That's a fact. The judge correctly found it was non-matrimonial. He doesn't actually make a finding about it being non-matrimonial. It suggests that that's likely to be his view about it. But it doesn't mean that non-matrimonial resources can't be invaded to meet needs, or even compensation if there were to be a claim for that. The wife had not sought a needs-based award at the original hearing, as her needs had been fully catered for by the approximately $5 million which she had thereby obtained. And the judge found that the needs of the parties had been met. In that submission, or rather that ground, is founded on paragraph 45 of the judgment, which is at 124. And I think Mr. Todd took you to this. At the last sentence, the parties were both intelligent adults with proper legal representation, had been properly advised on the risks inherent in the order, were satisfied that their needs were met, and seemed to be content for the order to be made. Approving the order was a legitimate option for DDJ Smith, and that is what he did. Well, what the judge is talking about is what was presented, the false story that was presented to the judge. That's all that's doing. It's not the judge finding that needs were met. Needs were not properly assessed in March 2022 by reference to the true landscape because the husband had committed a fraud. I'm going to look quickly at a few parts of the transcript, which is in the supplemental bundle. Page 28.
Sorry, page
28 of the supplemental bundle. Miss Westpiecer for my client says, well, that again, there is an issue that is in dispute between the parties, is line 8. There are compromises that have been reached about disclosure, about the factual basis of the case. One of the reasons, sir, we would say there is a departure from equality because Mrs. Copinger-Symes strongly believes that he will benefit in the future. Pause there to think, actually, this is a man who's on, I think this was a video hearing, he's on this video line and he knows that he's going to be benefiting, not just in the future, on the 17th of March the letter's going to be sent to him, offering the money. And the husband's solicitor says, sir, he's not a shareholder of the company, he's a director. Parties do receive the same income from the company. They each receive exactly the same. I see, and how is that going to change moving forward? Well, it's very much hoped that this is not going to change. Well, I mean, this is not going to change. I mean, all the funds are going to be moved out of the companies and put into Robert's estate. Well, the Deputy District Judge says, sorry, one at a time. So the intention is for that not to change. That's going to continue, is it? Ms. Sister says, indeed. The Deputy District Judge says, okay. My client's solicitor says, from Mrs. Copinger-Symes' perspective, she believes that Mr. Copinger-Symes will earn more than her in the future. But again, it's a dispute, sir, between the parties. Okay. And the husband's solicitor says, sir, by way of illustration, the parties did receive some funds from the parents in December, significant funds, and they've received the same amount. So my client says that this is indicative of the way the parents are behaving and that they are treating each of them at the moment in the same way in terms of the sums that were provided to them in December. Well, obviously we know she can say that because she's being lied to. But her client is in court on the video link hearing this, in spite of the fact within a few days he's going to receive $14 million US. Okay, now that figure, sir, that figure paid in December, is that reflected in the asset table? No, sir, it's not. That's an old schedule, it's not been updated. What was the amount received? Then if one comes down, 14, my client's solicitor, sir, you'll see also in the order the parties have tried a number of additional recitals which are aimed at trying to assist the wife in repairing the relationship with her parents. But I know Mrs. Copinger-Symes is very keen that I do point out to you the relationship with her parents is particularly bad at the moment. They've just evicted her from a property, and so at the moment relations with the family remain very strained. I see. And there are these loans, which there seem to be differing views as to what will happen with these loans in due course, as to whether they'll be forgiven or not, and both parties have given undertakings to use their best endeavours to ensure they're forgiven. So what is the background to the loans? So, sir, my understanding is the entire family have used loans in the past as a tax-efficient mechanism of passing money, so that these loans that my client's parents have made to my clients, the parties, historically, those loans have not been enforced. Although, as I've alluded to, unfortunately, recently my client's parents have started to enforce any financial assistance they have given where there is a loan element to it. And so there is by no means a guarantee that these loans will not have to be repaid, although the parties are both hoping that they may be able to convince my client's parents not to enforce payment. Well, you'd have thought Miss Sisk was properly instructed by her client, truthfully instructed, she would have said at that point, well, actually, all the loans to your client's siblings were forgiven last year. Well, yeah. Yes. And, yeah, and yes. And James's loans are going to be forgiven and we're going to pursue you for yours. None of that is said. Not just the needs assessment, but the whole process is vitiated. That whole process in front of the Deputy District Judge is vitiated by the fraudulent non-disclosure. And it's quite obvious that that's accepted by Judge Hess when he gives his specific examples at paragraph 65, but they are not. Yes, there's one more point. I do apologise. If we go back to the transcript to page 30 of the supplemental bundle. At line 14.
Sorry, which page again?
Page 30, 30.
Sorry, 330.
Sorry, 30.
30. Thank you.
The DDJ.
Yes.
Well, sir, we very much hope that those funds may well be open to her in the future and that bridges will be rebuilt. And I would raise the point that I've already made, that both parties have received significant funds from the wife's parents in the last 6 to 8 months, and they've received that in equal sum. And I think it's indicative of the way that they have been determined to treat her. They have indicated, as I think everyone is aware, that these ongoing matrimonial disputes are unhelpful for the family generally, and that they want them to be concluded, and they will be more minded to be forgiving and to repair relationship when these proceedings come to an end. And so it's very much hoped that when this order has been granted, that they will then assist in rebuilding the relationships. So there it's being said on the husband's behalf that it's indicative of the way they have been determined to treat her equally. My lords, my lady, unless I have anything else I can help you with.
No, thank you very much. Yes, Mr. Todd.
My lord, shortly before the luncheon adjournment, we were able to obtain copies, and I hope they've made their way to your lordships and my lady, of the
Yes.
one has got 1757 in the bottom right hand corner. It's the email that went to the judge.
Oh, good. Thank you very much.
And the other one is the husband's position statement.
Right.
Lord, I don't think the husband's position statement adds
Okay,
anything,
but thanks for finding it.
anything of significance. But the note at 1757.
Richard, we've got the Forms E as well.
Sorry?
We've got the paper versions of the Forms E.
I'm not sure we need them. Thank you. Yes.
The note at it's marked 1757. That's its reference in the trial bundle that was before the court.
I see.
So it was in the, I think, 6,500 pages or so.
Yes.
But at 1760 in that document,
Yes.
there's the answer to my lord's question earlier
Thank
about
you.
was this a sharing case? And it palpably was a sharing case. What happened was the parties agreed this was a sharing case, and then the district judge inquired as to whether the needs were met by those shares. That's what happened. And we see that in the fourth paragraph up at 1760, where it says the court will see that the parties have a departure from equality in favour of the wife. The reason for the departure is due to the provenance of the assets. The party's wealth largely originates from the wealth of the wife's extended family, largely, of course, whose wealth was established in recent litigation in Singapore to be in the region of 700 million. The husband remains close to the wife's family and is a director of family business, John Manners. The wife does not believe that her parents will forgive their loan. And that is the sole basis on which 50-50. That is the lingua franca of a sharing case. This was a sharing deal. And then it was the Deputy District Judge who said, well, I must check, as of course he needed to, that achieved the needs of the parties. My Lords, I just have one or two other points to deal with by way of reply. My friend said the Form E's were not before the judge at first instance. That's not entirely right. A 2-page extract was before the judge, and that was where the wife referred to her parents having 800, an inheritance potential of 800 million, and that she felt that she had lost her share of that because of the involvement of the husband. So we were saying that that's where she had the knowledge from, and that was in the Form E. But only those 2 pages in the supplemental bundle were there. My learned friend spent some time saying about whether the judge found the position on needs to have been established. Well, your lordships will have read and no doubt reread the judgment, but it's really in 2 parts. It's the paragraph 45, which my learned friend took the court to, as indeed did I.
Yes.
Which says about the judge was satisfied that the needs were met. And then, of course, he picks it up again where he says at paragraph 89, at page 139, that his provisional view, although we couldn't see any reason why this would alter, was that any change would have to be on the basis of need. He then goes on to expand on that to say, well, really there are 2 areas where need is significant, and that is in respect to the loan, and that is in respect of the ending of the £6,000 per month. It's not an invitation to, as the wife has since done, produce a budget saying that she needs 2/3 a year to live on. And again, significantly within that, slightly above that, paragraph 88, there is the reference from, again, the Deputy High Court Judge, emphasising that it was the intervenor's clear wish for the wife not to benefit from the gifts. It's the very last sentence that is put in there.
Yes.
We disagree with my own friend about the significance of the finding of foreseeable or foreseen. This wasn't some arid finding in the context of barter jurisprudence only. This was generally in respect to the case. The wife did foresee, it was foreseen, that there was a huge fortune that could be made available to the husband. And the dispute between us is simply how that came about, whether it came about by gifts or whether or not it came about by regular payments which were converted into gifts for tax purposes. And it's that which is the point about there was not a material non-disclosure. And we do accept my Lord's point about there's a 2-stage test, and we accept there was non-disclosure. Our point is the materiality did not alter the substance because it would not have resulted in a different outcome. And picking up on my lady's point about the definition of substantial, I'm afraid I'm compelled to echo what my known friend said, was substantial is always going to be in the context of a particular case. But one of the attributes of the word substantial is not just its size, but that would seem to be part of it, but also that it should be in substance. And what we had in this case were 2 things which were of controversial substance. On the one hand, there was a gift which might be postponed for her if the wife was to benefit from it. And then on the other hand, there was the 62 million the wife believes she was entitled to and is litigating over still in New South Wales. Both of the parties would have had a sense that each of them might want to make claims, might receive subventions in the and so on, so on. The point is they knew about those and they decided that this settlement, its fairness and finality between and your lordship to allow this put an end to what has been a series of reservations for these parts. I don't know if I can assist my lord or my lady any further.
Do you have any? No? We're just going to break for 5 minutes.
I've been poisoned too often. Right. Let's get in the Okay, so it doesn't for the social correction on the heads. Do they not?
I think it's okay.
My brother would do that. For example, on the name of the place, there's a say something like huge account of Australian Army. He reckons he suffered a actionable injury there from the compulsory heavy drinking that he had to endure. Because it was on a different scale. Good one is on.
What, right, David?
Thank you. We're obviously going to reserve our judgments in that appeal. We were just having a think as to whether to go on, but it's been rather hot in here.
Yes.
So unless it would displease you enormously, we're proposing to break now and start again tomorrow at 10:30.
Thank you, Lord.
If that's all right.
What, right, David?